If you're watching this video, I'm shooting this video on the 25th of December 2024, Christmas Day. So this is my Christmas gift to you. And that's because we want to talk about gifts in law. So if you're watching this video, I'm filming from Lagos, Nigeria. Let me know where you're watching from and what day or date you're watching. Let's talk about gifts in law. Now, this is going to be a double-decker video. It's a double gift I'm giving to you this Christmas because we're going to be having theory and practical in one video. If you've been watching this video for over 4 years that we've been talking law on this channel, you would know that when we talk about theory in one video, then we do a practical video where we do the drafts. When I say practical, I mean the drafts. There's more practical we do, we do scenarios and whatnot, but I'm specifically referring to drafts in this instance. So we'd usually do a draft video much later after we've talked about the practicals and the procedural aspect. But today we're going to be doing the two in one video. So that's my gift to you. And because we're going to be talking about gifts, also because of the significance of today, which I'm going to be linking much later. What is a gift in law? A gift is a voluntary transfer of personal property without consideration. It's as simple as that. Now, let's look at the keywords. Voluntary, that is, there's no compelling, there's no inducement, there's no duress, there's no demand, from the party that needs or wants the gift or that the gift is going to, or from a third party. It is voluntary. It is by free will, by choice from the heart. So that's a gift. A voluntary transfer. When we talk about transfer, it refers to something moving from one point to another. So it moves from one person to another, one party to another. Voluntary transfer of personal property. What are personal properties? Personal properties or personal property, could refer to landed property, to chattels, movables, immovables. It could be houses, land, car, monies in bank, cash at hand, and so on and so forth. Without consideration. What is consideration? We've talked about this in the videos that we did on contract law about 4 years ago. Consideration just means that what you furnish for value. In a contract, there are two parties, and usually one party gives something to another party in exchange for something else from that party. That is what is meant by consideration for value. So you furnish a consideration for the value that you're receiving in a contractual relationship. But in the instance of a gift, there is no consideration. For instance, if you want to buy water, maybe in Lagos traffic, for instance, you give money, a bottle of water is 200 naira. So you pay 200 naira, you get a bottle of water. That's the consideration. The money you paid, the 200 naira, is the consideration for value. But in the instance of a gift, there is no consideration for value. So if someone were to give you a bottle of water for free, that is a gift because you have not paid the 200 that you would have paid were it to be a contractual or a commercial transaction. So a gift is the transfer, voluntary transfer of personal property without consideration. So essentially, there are two parties in a gift. There may be more, but there are usually just two sides. We have the donor and the donee. The donor is the person giving the gift. The donee is the person receiving the gift. So what is in between them is the gift. So donor, gifts, donee. So there's a gift in between the two of them. A donor is the giver, a donee is the receiver. The gift is what is being given. So this explanation connotes a lot of things. It shows that the donor is capable of giving out the gift. So he must be in a good position regarding that gift. That is, he must have the lawful authority, capacity, capability to give out the gift. You can't give what you don't have. Nemo dat quod non habet. That's one of the most common, or rather the commonest, one of the commonest Latin maxims. You cannot give what you do not have. And by having it, we don't just mean a possession. We mean lawful rights or authority to actually give it out. And then the gift also signifies the fact that it must be something that can be given out. You can't give what cannot be given out. So the gift must have the quality of being capable of being given out, if you understand what I'm talking about. Air now, the air that we breathe. You can't give out air because you don't have it. You're not the true possessor of the air that we breathe. You're not the owner of the air, so you can't give it out. So it is not capable of, it's not something that can be given out. So that's for the quality of the gift. And then we have the donee. The donee must be in a lawful or right position to receive the gift, and we're going to be talking about much later. But there are types of gifts, and usually the type of gift would signify or connote the intention of the giver. So we have conditional gifts, unconditional gifts. Conditional gifts are gifts that come with a clause, a condition that must be fulfilled, else the gift may be nullified or the gift may be revoked. For instance, if I say that, okay, I give my 4 flats at number 47 Isaac John to my younger brother, provided he graduates with the first class, that's a conditional gift. If he does not graduate with a first class, he does not get the 4 flats. So it is revocable. Conditional gifts are revocable. So if the condition is not fulfilled, it can be revoked, and lawfully so. Then we have unconditional gifts. That's gifts that do not come. Those are gifts that do not come with a condition. So it is an absolute gift. It is given out completely without any encumbrances or conditions, and so it can be enforced. So unconditional gifts are enforceable. That is, when the donor gives the donee, if the donee does not get what has been given, he can sue. He can sue to get that gift. He can sue. He can come to court and say, "Oh, I was given this gift. There's no condition attached to it, and I haven't gotten it." Or maybe so person has encumbered it, or the donor has not released it, or has not done so and so that he or she is supposed to do. So it is enforceable. The right that comes to the donee of an unconditional gift can be enforced in law. Now, this is Christmas. It's a season of gift giving. Tomorrow is Boxing Day, when people will share gifts, unbox, gifts. So it's a very wonderful coincidence that we're talking about gifts today. So you can think about the gifts that you're giving out, in the light of what we're talking about. And what is more, the most important gift that we're celebrating at this time, the one that God gave to the world, Jesus Christ. It's I want you to let me know in the comment section, is the gift of Christ a conditional gift or an unconditional gift? Just for us to understand what we're talking about. So Christ was given to us, and that's what we're celebrating this Christmas. So in that instance, God is the donor, we are the donee, and Christ is the gift in between us. There's no consideration for the gift because we haven't paid anything for that gift to be given to us, and it was voluntary, given to us by God, voluntary. So I hope that we are making sense, and I hope that you are appreciating the topic as we're relating one thing to another. Even though giving is so common, and it's something that's done every day and every other day, there are some things to look out for, especially in the instance or in the case or the event of litigation or a misunderstanding or contention. There are things to look out for to be able to ascertain that a gift has been given, or something is a gift, or a transaction or an interaction or relationship, depicts giving or a gift. And they are as follows. One, there must be voluntariness on the part of the donor to give out the gift. Voluntariness. So it must not be compelled, must not be under duress, it must not be under a specific condition. It must not be maybe trade by barter. It must not be, blackmail. There must be no blackmail, no compulsion, from any quarters. It must be voluntarily given. So voluntariness is one very important feature of a gift. Another one is intention to give. Remember that in contract, we talked about intention to create legal relations. So in gifting too, or in gifts, there must be an intention, express intention to give the gift to the donee by the donor. And then there must be the gift, of course, which must be capable of being given out which the donor must have lawful authority or capacity to give out. No encumbrances, no conditions, no attachments, nothing that prevents the donor from lawfully giving it out. So there must be the existence of an unencumbered gift, and also there must be delivery, of the gift to the donee. So it's not just something you say, I give. If it's landed property, for instance, there should be an occasion where the donor takes the donee to the land in the presence of witnesses and says, oh, this is the land, the 2 plots of land at Ibejuleki that I'm giving to you on the occasion of your birthday. And then so that there must be delivery. Okay, enter into possession, and you can now begin to do as you please as the donee. Or if it's a car, you give the car key to the donee in the presence of witnesses, of course. So that is also a condition. There must be delivery of the gift. If you're giving, maybe a box of diamonds, it can't remain in your possession and then you say it's a gift. I've given you. No, you must deliver it to the donee, and then there must be acceptance. In the absence of acceptance, everything falls through. It is not a gift validly given. So there must be acceptance of the gift. So if the gift is rejected, then it is not a successful gift or giving. So there must be acceptance. So those things must be present. Those are things that you look at before you can say that a gift has been given. When we're doing the drafting, we'll see some of these things in the deed of gift. So the deed of gift is the document that you prepare to pass the gift. Usually a gift can be done verbally, a parole, but it is important and preferable and safe, legal, lawful, especially in this day and age, to document the giving, and it is done by a deed of gift. Especially if you are even giving out landed property, the statutes of fraud has provided that when in dealing with land, if you're gifting out land, it should be documented. There must be documentary proof. You should execute a deed of gift, to show that you have given out that landed property. It could be house too. When we're talking about landed property, we're not just talking about bare land. You should execute a deed of gift, and that takes away in most instances all contentions and all doubts. So there must be that, and the deed of gift will contain also witnesses who also signed to attest to the fact that that gift was given and they witnessed it. So we'll talk about that when we're talking about the drafting, when we're looking over or drafting the deed of gift. But essentially, these are the conditions, these are the features, these are the qualities that you look out for. The gift must be given in the presence of witnesses. Very important as well, especially to eschew all contention. Now, it's important to look at 2 types of gifts. Gift intervivals, which is something we've talked about. There's a short that we did about 2 years ago on the channel where we talked about gift intervivals, and then there's gifts causa mortis. Gift intervivals is the gift that you give in your lifetime. It simply means gift in the lifetime of the giver. Gift causa mortis is the gift that you give in anticipation of death. So it's revocable in the sense that if that death no longer falls through, then you can recall the gift, you can nullify the gifting. So for instance, I've read a few times, people sharing that their grandma, was anticipating her own death and then called her children and gave out what she owned, maybe trinkets, monies, cash at hand and stuff. And then she said she was going to die maybe the next day. And then it's 2 weeks, it's 2 months, and grandma is still ill at hearty. In that instance, the gifts she has given out can be revoked. They are revocable. So she can call them back and say, give me my things back, or because she has not died. So that is gift causa mortis, gift in anticipation of death. Now, gift intervivals is gift in the lifetime of the giver. Both gifts are very important, and there are 2 types of gifts that can be giftings that can be done. Now, gift intervivals can be useful to transfer interest while you're still alive. It's good, especially if you are not going to make a will, and so that you do not die and if you are going to die intestate, or if you plan to die intestate, so that there is no problem or contention over your estate. You can give out what you have in your own lifetime. So the only difference between that and making a will is that in a will you can preempt or cover some of the things that will come in after your death. But gift inter vivos, you can give out. So, for instance, you don't want to make a will. Maybe you have a few houses. You have, royalties coming from some intellectual property. Some jobs, some works that you've done, and you have, maybe cars, clothes, trinkets, important things that you want to give out. You don't want to make a will. You don't want your beneficiaries or inheritors to start fighting at your demise or upon your demise. You can give it out in your own lifetime, and you can execute deeds of gifts, with each beneficiary, with each donee, to say that, okay, I give you this house that is at number so 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 so. I give it that land that is at number so so, because it is gift inter vivos. They come into possession and they take over, while you are still alive. You know that if you make a will does not become operative until you have died. So it is a document that takes effect when the testator has died. But if you give out inter vivos, they can take over what you've given to them. The donee must accept it while you are alive, and take delivery of it. So that's just the difference. So you could do inter vivos, if you want to test your future beneficiaries, just to see how they might manage your property in your demise. You could give out some things inter vivos. You could also gift inter vivos to avoid taxation. So it's a very smart or safe means of evading tax, because gifts are not taxable. Gifts are not taxable. The law may change tomorrow and gifts may become taxable, but at the time of making this video, gifts are not taxable. So they become a part of your tax-free estate or income. And because they are going to be transferred to a donee, they are no longer yours too. So if you're trying to evade tax, you're also losing property, because if it's an unconditional gift, you cannot revoke it. So you can't take it back. That's also another quality of gifts. You can't take gifts back. So it is more serious in law, especially if you've executed a deed of gift, which can be enforced against you by the donee. So it's not the usual informal gifting where you maybe change your mind, maybe the person insults you and you say, I'm not giving you again, give me back my car. That is not how gifting is a serious affair. So it is a legal transaction, although not so properly called, because there's no consideration for value. But once you have given it out, even if you're trying to evade tax, it becomes that of the owner. So but it falls out of your own taxable estate, taxable income. So also you can give, I've said you can give it out, to test how your beneficiaries may behave. You can also give it out, to avoid taxation. That should be tax avoidance, not evading. So to avoid taxation, you can give it out. And you can also give it out, for peace of mind, if you do not intend to make a will. So that is gift inter vivos. Now, gift causa mortis, I've said, is the one you give in anticipation of death, but you can revoke. So it can come back to you in case you do not die. So once a gift has been given, in order to formalize and legalize it, it is better, it is safe, it is important to execute what is called a deed of gift. A deed of gift is a written document that shows that the gift was actually given, and it is a document that helps with enforcement. It is registrable, so it can be registered just like a deed of assignment and any other deed. So it's a registrable document or instrument, and it is a very vital proof, of gift in any litigation or in the event of any contention. So we're going to be looking over a deed of gift, the important clauses, and how to draft a deed of gift. Also, please note, I've said it, but I'm repeating that in the event of giving out landed property, especially, the donee must be taken to the land. The land must be handed over in the presence of witnesses, and the donee must accept. He or she must accept. There must be those, qualities that we talked about: voluntariness, intention, the gift itself, free of encumbrances, being able to be lawfully given out, and there must be delivery to the donee and acceptance, not just in landed property, but in the instance of giving generally. There must be delivery and acceptance, for a gift to be valid. Let's go to a deed of gift. Here's a sample deed of gift that exemplifies or illustrates what we've been talking about. Deed of gift between Mrs. Ire Adu, the donor, that's the giver, and Mrs. Jolly Oluwalulokpe, that's the receiver, the donee, prepared by Mujola Olua Livingstones of OM Livingstones and Co. And that's our email address. So this is basically a title page, or the first page, a cover page rather. So you can make yours however you see fit. There's no other fast rule to that. So we go into the parties clause and the date clause to open. And it's important for you to know that your own deed of gift may not necessarily contain all the legalese that you would find in this particular deed of gift. This is just a sample. What you need to make sure of rather is that the important features are contained. That is, there's a giver and a receiver. There's an intention to give, to pass the property to the receiver. It's a voluntary giving, and the property is capable of being given out. The giver has lawful authority to give it out, and there's no encumbrance on the property. Also, there's delivery of the property to the receiver, and there's an acceptance on the part of the receiver. If those things are clear, however you choose to word it, you are home and dry. This deed of gift made the 25th day of December 2024 between Mrs. Iriadu of, we have her address, and then Mrs. Jolly Oluwalulokpe, we have our own address too. So when we say that it includes, their assigns, their executors, administrators, and heirs, what we're saying is that if anyone has been dealing with the property on behalf of the donor, or if anyone will deal with the property in the future on behalf of the donee, whatever happens or affects the donor or the donee affects those representatives. That's basically what we're saying by that addition. And then so here we have the date clause and the parties clause. Very clear. And then we go to the recital. The recital is very important because it is where we trace the root of title. I've always said this, that recitals are very important in any transaction, in any document or any agreement, especially land agreement. It's important because that is how you trace root of title, especially in the event of litigation or contention. So it's important for you to inquire of this information. If you're a lawyer preparing a deed of gift, you should ask for all the information necessary. You that you want to give out the property, how did you come about the property? How did it become yours? Who owned it before it came to you? So you need to describe those things so that, when there's litigation or contention in the future, they start to trace it from the recital clause. And it is easy, it is clear. Very important. So here we have the recital clause, whereas. Once you see whereas, it's recital clause. So it has 3 paragraphs which will state, how the title came to the giver, and that the giver is giving it out to the receiver, and that the receiver has received it. So in the recital clause, we are shown, or we are told, or it shows us that the giver is a beneficial owner of the property. The property also is properly delineated and described. Very important, so that there's no confusion. You describe the property to the detail. So if you're giving out a car, you must tell us the make, the color, everything that will help to identify the car in a sea of cars. So if you're giving out a plot, for instance, out of an acre of land, it must be properly described so that the donee does not think, or any other person acting for the donee, so that they do not think that it's more than what they've been given or less than what they've been given, or so that they do not think that it is something else. So if you're giving out a flat or a room in a block of flats, for instance, it must be so clear that when the donee is trying to come into possession or act with respect or in respect of that gift, they do not make a mistake and then go into what is not theirs and what has not been given to them. So someone owned the gift, that's the parcel of land, that's Madam Kolawole, and that's the registration number. So if a donee wants to confirm the title, for instance, to be sure it's a valid title, all these details are there to help them confirm. And then Madam Kolawole owned it and then sold it to Miss Mojisola Fatai by virtue of a deed of assignment. It's a deed of assignment because the land is covered by a CFO. Lands that are governed by the Land Use Act are usually covered by a CFO. And so when you transfer them, because such lands, the government only gives you 99 years on such lands. So when you're transferring or selling those kinds of parcels of land, you are only assigning what is left of the 99 years. So when you buy the land, maybe you bought it from the government or you got it by a government allocation, or let's even say that you bought it from someone that got it from the government by government allocation, and the person has spent maybe 10 years on the land. Now you buy it and you spend 16 years. That's 26 years. So that's 99 minus 26. So when you are selling it, you are assigning what is left of the 99 years to the next owner, who would also use it. And if they also decide to sell it before 99 years, they are assigning what is left of 99 years. So that's essentially why it's a deed of assignment. You are assigning what is left of the 99 years that the government assigned to you to use on the land or to use the land for. So it was sold to Miss Mojisola. So Miss Mojisola then sold it to the donor, who is now giving it to the donee. Now the consideration, remember we said that there's no consideration for value in a gift arrangement. That means you're not paying anything as a donee to receive it. But you would often find that the donor will put a form of consideration that is not monetary. For instance, it could be, for someone's meritorious service in a company or under a master servant arrangement. It could be, for securing a contract, doing something very tangible, something that the donor appreciates. In this instance, the donor is giving the donee for a commitment and loyalty and a long-standing friendship that they have shared, and of course on the occasion of the donee's 46th birthday. And now the other clause, the other paragraph is saying that the donor is desirous of conveying that gift. So that's the clause that shows that there's no compulsion, it's voluntary. It's conveying that gift to the donor, to the donee, and the donee has accepted it. So that clause must be included to reflect voluntariness, intention, delivery, and acceptance. This clause shows again the consideration for value, which is appreciation of a long-standing friendship, and then it describes the property in greater detail, not just to show the number, the streets, the area, the state, but also stating that it's free from all encumbrances. That is very important, must be included, because it is an enforceable clause, an enforceable statement, an enforceable qualification of the gift, that it is free from all encumbrance. So now you can enforce that against the donor in the future if you find out that there's an actual encumbrance, that was not disclosed, or that was not dealt with, before the gift was passed to you as a donee. So also it shows the square meters and the survey number, the surveyor's name, to the greatest detail, the finest detail. Everything is there. The date of the survey, and to show that the donee going forward will now become the beneficial owner instead of the donor. And then we have the covenant clause, which is paragraph 2 and 3. In any agreement, there must be covenant clause. So those are the things that both parties have covenanted to do in relation to the object of the transaction or agreement and in relation to one another. So the donee covenants here henceforth to pay all lawful rates and levies in respect of the said land as may be prescribed by the government from time to time. So because the donee is becoming the beneficial owner, anything that the owner of the property would have done, the donee has to now do it. For instance, if it were a rental property and the landlord would usually, pay maybe landlords association fees, power connection fees, land use charge, all those things. Now the donee has to pay them because the donee is now the owner. So you can't call up the landlord or the donor and say, oh, they're asking me for land use charge. They're asking me for area rates or tenement rates or whatnot. Please come and pay. No, because the gift has passed to the donee. The donee is now the owner and will be responsible. Just as he benefits from the gift, he will be responsible to pay for all rates and charges accruing to the property. And the donor also covenants for vacant possession and hereby puts the donee in full possession and exclusive possession of the said land. So that means that if, for instance, it's a property that's being occupied, maybe the donor has given some people lease or has given them, maybe some permission to use the property. Maybe some people are farming on the land or they're using it as a mechanic workshop as is common in Nigeria. Now it's the donor's responsibility to get them off the land, to deliver a vacant land to the donee. There may be an informal arrangement to say, okay, let these people finish what they are doing and then they'll leave, or talk to these people. Do you want them to continue and now to be subject to you? That's donor talking to donee. But ordinarily, the donor must deliver a vacant possession. He must covenant to deliver vacant possession. That's part of the encumbrance, the free from encumbrance, clause. That's what it means. So the property must be completely free and delivered to the donee in such a way that the donee can immediately enter into possession and begin to deal with the land as though the land were his, because it is now actually his. So that's the covenant clause. If there's any other thing that the donor or the donee would like to covenant to do, they put it in the covenant clause. So after the covenant clause, we have the witness clause, where you say, in witness whereof the parties have set their hands and seal on the day and year first above written. You can practically use those two lines for any type of agreement as witness clause. And then you put the name of the party, signed, sealed, and delivered party. That's donor who sign in the presence of the donor's witnesses. Advisably, a witness or two is sufficient, and then donee will sign in the presence of the donee's witness, and that's all about the agreement. And then you register it. That's when you have the governor's consent. So there's a presumption that this has been registered. You remember I said that it's a registrable instrument. So deed of gift is a registrable instrument. You can register, get governor's consent on it. So that makes it final in the sense that it's not revocable. So once you've done this deed of gift, it is final. The property moves or becomes that of the donee. So it's not an unserious situation where you say, oh, I'm not giving you again. You can't do that because you can't undo governor's consent. And this is a document your witnesses have signed. So you can't just wake up maybe in a fit of anger or regret and say you want to get back what you have given under this type of agreement. No, it's a serious and a final agreement. Linking it back to Christmas, I hope you enjoyed this double-decker video where we talked about gifts in law and then talked about a deed of gift, where we also highlighted the fact that Jesus is the greatest gift that God gave us at Christmas. So if you look at the features of a gift, you would note that there's a donor, which is God, the gift, which is Jesus, God having the lawful right or capacity to give that gift to us. There's delivery, and what finalizes it is acceptance. So I hope that as you listen, you have accepted that greatest gift. I will see you in my very next video. Please bring a friend to Battle with Ola and don't forget to subscribe. Merry Christmas. Toodles.